Hello, welcome to our 21st Women in Sectional Title webinar. We're 21 years old in terms of our events, and we have actually come of age, which is just fantastic. I think that it's important for us to successfully forge forward, and we know that we're going to do that with the support of our sponsors. So thanks again to all our sponsors, ZFIN, CIA, BCM Track. We've got Meeting Pal, We Connect You, and Sectional Title Solutions. So thank you. Can everybody hear me? I don't know if you can just put in the chat group. There's certain people who can't hear. Yes, you can hear. A few more people just type so that I know that you're there. Yes, good. Okay, fantastic. Good. Thank you. Okay, so some good news for everybody is that Women in Sectional Title is actually taking the opportunity to support a training program of 6 weeks where I'm training ladies on a Saturday from the inner city. They chair ladies in the inner city, as well as from Soweto. So I've got 14 ladies currently that we are, doing the basic training for. And I think it's a really fabulous opportunity for us to earmark good, solid people who really, really want to come forward and maybe do an internship at a managing agency. So if anybody's interested out there from a managing agency, I think there are probably 3 or 4 ladies that I see have potential, and maybe we can, practically bring people in and work side by side with the Property Practitioners Act. So yeah, let's do that. Today, we're talking about what you need to know about dealing with service providers. And this is a little bit of a murky area of the law, and I think it's a valuable opportunity to discuss the practicalities as well as what the law has to offer. So we're speaking today to 2 ladies, Danielle Crewe. Danielle is the Senior Portfolio Manager at Stonewood Property Management in the Cape. Hello, Danny. Hi. Say hello to everybody.
Hi, everyone.
Welcome. And Karmel Pringle. Karmel is a portfolio manager at Maxprop in KwaZulu-Natal. So we've got the coastal people. Hello, Karmel.
Hi, everyone.
Thank you for being with us today. So before I start and before we delve into questions relating to all the dealings with service providers, I want to set the stage. And if there are any younger, sort of more inexperienced portfolio managers or trustees who haven't had a great deal of experience, let's look at the foundation of a trustee and a managing agent's relationship, because the managing agent cannot be the tail that wags the dog. And so very often that is the case, because managing agents become the driving force around service providers, and trustees kind of relinquish their role and just rely on those managing agents. And I think that reliance can be a little bit dangerous. So managing agent is exactly that, an agent. And we've got our trustees who are in charge. They make the decisions. So when you've got a situation where a service provider is appointed, what happens? I mean, at the end of the day, that service provider is really bad. Can the body corporate say, well, we're going to sue the managing agent? Or it really does stop with the trustee. So I think if trustees understand this relationship, it's a little bit easier. But of course, we know that in practice, it might not be the case. And that's really what I want to talk about today. So we've delineated the relationship between the trustees and the managing agent. Danny, I'm going to start with you. In your experience, what is the situation with appointing service providers? Who really gets to appoint the service providers, from your experience?
Yeah, so thank you for inviting me. So basically, we act on instruction by the trustees. So they would inform us as to what kind of work needs to be carried out. And we will then contact service providers that is on our database. We normally ask for about 3 quotations for the trustees to review and approve. We do not make that decision for the trustees. So we would go out and we would get that information and assist the trustees with getting the relevant service providers to quote for that particular work that needs to be done.
I mean, there's nothing in the sectional title legislation that specifically deals with procurement, right? And Karmel, if I can just ask you, what kind of service providers are we looking at that you deal with on a daily basis? Who are the service providers in a community scheme kind of environment?
Okay, that'll mostly be gate technicians, plumbers, electricians, obviously all only for common property related matters. But yeah, those are the generals. And then obviously if you've got some roof issues, then it's roofing contractors, that kind of
those guys who are fixing stuff. But I suppose you could also add to that list, like if you're choosing a bank, for example, a bank is a service provider. Attorneys are service providers also. I've tried to make a list of them, your insurance companies, and then obviously security intercom systems. So there's a lot of interaction that you guys are having on a daily basis with everybody. And if I can just say, I wanted to read something from the Chief Operating Officer of Estate Living, Louise Martin. She says, the tender process should provide a solid framework to govern the appointment of a new vendor for a project or scheme that bypasses potential bribery and nepotism. It all depends on the scheme, and custodians must be aware of what legislation applies. So Danny, you were talking about the three quote system. How do you go about working together with trustees to see what their requirements are? Do you guys meet on a regular basis? Is there, are you sticking to maintenance, repair and replacement plans in terms of these type of things?
Yeah, so we would meet with the trustees as to find out what their requirements are. But just going back to the procurement process, it obviously involves in-depth understanding of what the requirements are, identifying the right service provider for that particular project, and when you meet with the service provider to ensure that they actually can carry out the work as specified, and then obviously evaluating the performance, negotiating the contracts, but all with the assistance and information provided to the trustees. Together they will make that ultimate decision at the end of the day.
Absolutely. And Karmel, do you find a lot of trustees, do you ever find trustees, like new trustees who come in, all of a sudden just want to get rid of all your service providers and contractors? Or, if you've got sort of the normal contractors that you use on a regular basis?
Okay, so we do have normal contractors, but we've also got a number of body corporates that have been using their own contractors since forever, since we've started managing them. And I've actually just had a change of trustees in one of my buildings, and those trustees have now decided they don't want the contractors that the previous trustees used frequently. They would now like us to assist in getting the service providers attended to. So yeah, we've got sort of, on the one hand, we've got our contractors, and most of the time, if we've supplied quotations from contractors or service providers, we haven't had many fallbacks because of that, because obviously we try to vet it as much as we possibly can within our scope of work, obviously, and the scope of our knowledge. I mean, I can't pretend to be a portfolio manager, but I don't know anything about building. I mean, I'm not in construction. So as much as we can, we try and vet the contractors as much as possible. And we don't have that many fallbacks. If we do perchance have a fallback, we deal with it then and there. And from there on, we basically stop using that service provider if we ever have a fallback.
So it's almost like a recommendation, a recommendation list that you provide. But isn't it amazing, ladies, that often owners think of you guys as experts in everything? Not only are you managing agents, but now you waterproof experts. You need to be electricians. You need to be all these type of things. I think it's can be quite stressful. Hey, Danny.
I think so too. I think I always say that as managing agents and property managers, we wear different hats. We wear compliance officer hats, we wear labor law hats, we wear HR hats. So yeah, we have to actually have our finger in the pie all over the place. But you know, knowledge is power. So we work with these service providers, and we also, you know, get information and can perhaps recommend, like you used the word earlier, recommend service providers to trustees. But again, ultimately, the trustees make the final decision.
Yeah, I think that we can't sort of say that enough. Yeah. But if we go into the talk to me about service delivery, and Danny, do you guys have any kind of service levels agreement with your contractors? Because I know a couple of the managing agents that I work with do.
Yeah, I think it's important when you recommend a service provider, a contractor, that they come with some sort of recommendation from perhaps another body corporate, another a company that they did work for, and based on that you can say, okay, well, we'll give the work to you, but then also you need to they need to have some credentials as well to show that they are the contractor that can do the work. Because without that, how would we know that that work is going to be completed to the satisfaction of the trustees? So definitely credentials are important when it comes to employing a contractor.
Mm. And how have you found dealing just with COVID and contractors? Has that become more difficult for you, or how have you dealt with that in terms of coming onto the property? Karmel, do you want to answer that?
It has become a little bit more, a lot more red tape to get through. But I think we've managed to work around it quite efficiently. As long as all protocols are kept in place, whether it be from the body corporate side or from the contractor. I mean, you can't expect a contractor coming in not wearing a mask, or, you know, things like that. So as long as everyone is following those general protocols, then it's working fine.
Yeah, absolutely. If we look at the definition of procurement, it says a structured method to streamline an organization's process while saving cost, reducing time, and building good relationships. And I want to kind of flesh that out a little bit. The saving costs, I mean, I think that must be a huge thing at the moment. I know for a fact from my body corporate, on the side of body corporates that we deal with, that, you know, a lot of people are falling into arrears. We've got, yeah, I suppose it's the impact of COVID, you know, on a lot of the buildings. So cost is key. Am I right, Danny?
I agree. Yeah. So basically, that is why we ask for 3 quotations from the service provider. The trustees would obviously review and then consider the pricing structure, the scope of work that needs to be done, the terms and conditions. So definitely costing is a factor, but it's not like the main factor at the end of the day, because you don't want cheap labor and then you have to come back like a few times to correct that work. So you need to obviously consider the fuller picture about the service provider's capabilities, his credentials, the long-standing relationship he has in the business, that kind of thing. So it's not all just about cost at the end of the day.
Yeah, I agree. And the thing is that also we talked about building good relationships, and I want to get into that because I can see there are quite a few questions as well, just about transparency and, you know, who's who in the zoo, and is this your brother-in-law's garden landscaping company, and are the trustees involved? But before I go into that, I just want to talk about these relationships, because, you know, not only do we have all these acts, and you were saying about, you know, and we've got Poppy, and we've got this, and we've got that. We've also got the Property Practitioners Act, which has become very clear on the concern around the relationships between the people who are giving instructions to the service providers and the body corporate as well. So the Property Practitioners Act basically says you cannot enter into any arrangement where a consumer is obliged or encouraged to use a particular service provider. Let me just read that again. You cannot enter into any arrangement where a consumer is obliged or encouraged to use a particular service provider. So they're talking about the property practitioner. We all know that managing agents are property practitioners. You guys as portfolio managers are property practitioners. So what do they mean when they say any arrangement where consumers obliged or encouraged? Well, how do you read that, Danny?
Yeah, there's different interpretations, I would think, but definitely, in our view, I think it's important that a resolution is drawn up. I would think that would be the first step by the trustees. So you would basically put on the resolution what type of work is being carried out, and then also the managing agent could also sign the resolution. What monetary restrictions are in place for that kind of work to be carried out, who's carrying out the work. So clear guidelines on the resolution. So that also in one way covers the contractor, is protected from entering into this contract by any unauthorized trustees. And then also the trustees are protected because they can't be then held personally liable for a contract with a third party without that resolution being in place and given clear guidelines. So there are many ways to approach that kind of issue.
Yeah. And I think also the Property Practitioners Act is trying to, probably in my view, it's trying to allude to the fact that you can't also enter into any like financial arrangements with anybody to get. Correct. So we're talking about kickbacks, right, Karmel? What are your thoughts on that?
Yeah, I mean, we've got a strict policy on that, and we can't accept, or even if it's as much as a box of chocolates for an approved quotation, we are prohibited from doing anything of the sort. If we had to, it has to be completely declared, etc. And it's not, you know what, I don't believe it's a good business practice anyways, in any case. And if you're trusting a managing agent, you're hoping that they are getting you the right service provider for you as the client, and nothing that's going to benefit them at the end of the day.
Yeah, I couldn't have said that better. I'm so glad you put it like that, because there's no benefit to a body corporate and to all the owners if any managing agent is obtaining kickbacks for work being done. You know, that's not a relationship. A relationship's got to be based on integrity, from my perspective, as well as service, actual service that you're getting. The minute money starts changing hands, it muddies the water. I know for a fact from our side as well, in terms of relationships that our conveyancers, for example, have with estate agents. There's so many estate agents that don't give conveyancers work because they want 200, 300, 400 Rand per transfer. I mean, that's not building a relationship in any way. So we want to build these solid relationships, I suppose. But for me, recommending people is fine. You know, saying to people, as managing agents, we're in a position of power. We do understand. We know who's in the industry. We know who's in the game. Here's a list of recommendations. So yeah,
Yeah.
that's absolutely fine.
Yeah, I think another point, Marina, is the fact that the Sectional Titles Schemes Management Act and also the Prescribed Management Rule allows scheme members to impose restrictions or specific directions on the trustees. So, for example, they could limit the amount of spend on a capital item, and then also restrict to contract with just one service provider over another. So that is where that restriction and direction would come in as well.
Very good point. Restrictions and directions, I don't know about you guys, but for me, they're not used enough in complexes. I think that there's a lot of leeway to be able to utilize the control of the body corporate and the owners to get involved with things. But obviously, you've got to allow flexibility and in a certain way. But I want to just know, as a matter of interest, while we're talking about restrictions, what kind of financial restrictions do you guys experience in your schemes? What kind of amounts are we talking about? And this might differ completely from body corporate to body corporate. Karmel?
Yes, I have a body corporate that actually specifies that for any work required at the body corporate, 3 quotations are required. I've got a body corporate that's got a limited spend of about 80,000 Rand. Then all owners need to be made apprised of this information. But anything below that, then the trustees are allowed to just make the decision. So I know that from my personal point of view, at our AGMs, when we get to that point and discuss it, I actually advise them it's best to put directions and restrictions in place, because it covers not only the trustees, but it covers everybody else in the body corporate, because let's face it, the body corporate is, everyone is paying money for the body corporate. Everyone is paying a levy. So it's not one person's money or funds, it's everyone's funds. So to put those directions and restrictions in place, it just makes sure that everyone is covered from that point of view.
Definitely. Danny?
I agree. And also, again, resolutions also just cover that as well, where you could actually give them, the trustees, contractual power to enter into agreements and for a certain amount. And again, if they're going over that amount that was agreed to by the members, they would then need to inform the owners and get their approval. So definitely it's just clear communication and transparency. That is what's needed.
Absolutely. I think so. Let me just have a look here. Deanne says, who has a disclosure form that all trustees and service providers sign for transparency, on any existing relationships, specifically if any family, etc., not to exclude anyone, just to ensure due diligence. Does anybody use that kind of form, Karmel?
Yes, that would fall under the resolutions that we've already been discussing. And absolutely, if it is definitely anyone connected to a trustee, 100% a resolution needs to be drawn up, because the owners are entitled to know that it's a family member or it's a connection of the trustees. Because again, it can be muddy waters again. Are they getting a kickback? What is the reason behind it? Is it just because they're a good contractor, or is it because it's family? It's now favoritism, nepotism, all of that. So yes, it would fall under the resolutions, and definitely a resolution should be drawn up.
Okay, so we've also got a few questions here, and Marianne says, what does a managing agent do when it is clear that trustees want to use a service provider that is linked to one of them? And the question that I had here was, can a trustee be a service provider? How do you deal with that when that comes up? Danny? Again,
If the remaining trustees are happy that the work can be carried out by a trustee who can actually contract to the work and provide the service, then they can agree on that. However, again, we take a step back. We it's again the trustees to approve that kind of work. We cannot get
Okay, it's quite a difficult, I think you guys are always walking a tightrope. Like you walk in a tightrope, isn't it, Karmel?
I would have suggested in a situation like that, I would have suggested a unanimous resolution of the body corporate, that the owners are happy that this trustee is now basically, because he's going to be, yes, he's providing a service, but he's financially benefiting by providing that service from the body corporate, and with him being a trustee. So I would have suggested a unanimous resolution in that respect, so that all the owners are fully aware, and if they're happy for him as a trustee to do the work, then to do that resolution.
Okay, so now I'm going to take you into the law on it as well. So I've got Section 8 of the Sectional Title Schemes Management Act. Let's just see what they talk about when they talk about relationships. Okay, so a trustee, this is now 8.2b, Section 8.2b, if you're writing anything down, have a look at it. Each trustee must avoid any material conflict between his or her own interests and those of the body corporate, and in particular, must not receive, number one, must not receive any personal economic benefit, direct or indirect, from the body corporate, and must notify every other trustee of the nature and extent of any direct or indirect interest, material interest, which he or she may have in the contract of this body corporate as soon as a trustee becomes aware of such interest. Okay, so, but it goes on to say, and this is, I think, the most important thing, it might be a breach of the trustee's fiduciary duty to have this material conflict, even if the trustees know about it. So then you go on to 8.1.8.4, Section 8.4, which says, this conduct does not constitute a breach if such conduct was preceded or followed by the written approval of all the members of the body corporate, where such members were or are cognizant of all the material facts. So it almost goes beyond trustees. It even goes beyond a unanimous resolution. It's the written consent of every owner. And I mean, you try to get the written consent of every owner for anything. I don't know, you might have better luck than I've had in the past with that. But that is really as sort of strict as it is. And my view is very much that it should be that way, because, you know, that's the bottom line. I see Berger. Hello, Berger. Nice to see you on a Woman in Sectional Title webinar. I see you asked a similar question about owners. You know, what if an owner wants to provide a service? And very often, I mean, owners can be professional, they can be proficient, they can have the best companies. I mean, you know, why wouldn't you use them? But again, you know, it begs the question, is there going to be a conflict of interest? Are you going to be breaching your fiduciary duties? And I think in that regard, steer clear, unless you've got owners written authority to do that.
Yeah.
Okay, Danny, do you want to say something else there?
I think that is where that is important to have that resolution regarding the restrictions and directions. So you can put all of that in there, so we won't have this kind of conversation again.
Yeah. Good. Good. Okay, then Elise says, what are the trustees, managing agents' responsibility towards occupational health and safety regulations? Do they need to comply with the construction regulations? Yeah, who would like to answer that?
Well, normally if you get in a service provider that's doing work that requires occupational health and safety, you would have that company provide that information. So you would ask for that information from that service provider.
Yeah, what we generally do, we actually go on occupational health and safety training with a gentleman in KZN. Look, I don't know if it's countrywide, but he does it here in KZN. And then following that, he provides us with a document. It's a mandatory agreement. And should we need contractors on site that specifically will require occupational health and safety and building regulations to be followed, everything is in that document that you give to the contractor prior to them actually going on site, and they have to sign it and provide all of their FEMA registration numbers, everything on that document before they can commence with work.
Because it's like an indemnity, so that
Yes,
it's an
so
indemnity that
yes, and it does, and it indemnifies the body corporate on losses that they may incur, as well as body corporate losses, so that they can go back to the contractor and claim losses that occurred while they were on site.
Yeah, I think that's really important, and I think we've actually offered before to send people one of those like templates of that occupational health and safety document, which probably should be signed. I think it's probably an interesting thing and we must think about having a webinar just on occupational health and safety, because that does impact. I mean, for example, if you don't have fire hydrants on each floor of a building, that is against the Occupational Health and Safety Act. And I dealt with a building in the Cape probably about 6 years ago, where the trustees were held personally liable because of gross negligence. At that point, you didn't need it wasn't just a breach of a fiduciary duty where you could actually sue somebody in their personal capacity, but it was also it was just gross negligence or fraud or dishonesty or whatever, and they were held liable for gross negligence on the occupational health and safety side. Also with like banisters and things like that. There's a lot that falls within the OSH Act. Yeah.
That also forms part of the procurement process, where you would actually conduct an audit on that service provider, which would obviously include review of that service provider's documentation, which should include occupational health and safety and any other documents that you need before you even contract them to do the work.
Yes, absolutely. And from a performance management point of view, again, Karmel, what do you guys do with the performance management? If somebody is not performing or they're really, really not doing a good job, how do you deal with that?
Well, firstly, if I ever get wind of a service provider that we specifically recommended along the way that has not provided a service, I first address it with the service provider, because it came from us, so it's making us look bad as well. I do provide them with an opportunity to rectify it and make good on what they had quoted for or what they'd promised. If they fail to do that, then we remove them from our list. That in essence, they will never get another job through us again. Okay. So not only on my portfolio, we remove it like blanket. So every portfolio within Maxprop is advised, this is what's happened, rather not recommend this person going forward.
Okay. I see Marlene says, in our CR, we stipulated that the plumbers or electricians must have the necessary certificates in place before entrance will be given. This is an enormous plus from an insurance perspective. Marlene, I wonder if you could just unmute yourself and maybe just come on. I'd like to explore that a little bit further, if you wouldn't mind. I just want to ask you a few questions about that. If you could just unmute yourself.
Good morning, Marina.
Good morning. How are you?
I'm very good, and welcome to everybody else. And thanks for this awesome platform for us.
Pleasure. Yes. Tell us about what you said.
We found that a lot of the plumbers, electricians, contractors as such were coming into the complex or complexes, and they, we call them the Bokkie Brigade. They had no certificates. They were causing major issues. Insurance problems just escalated from there. And then when we drew up in this one specific complex, drew up the conduct rules, we decided, put into the conduct rules that when you get a contractor in, number one, a plumber electrician must have a proper, valid certificate. And secondly, when you have bigger contractors that are doing more OSHA type of thing, then they must be able to be checked so that they are health and safety compliant. Because at the end of the day, bringing these contractors in and they're not OSHA compliant, the owner takes the fall for it if the owner has employed them. And if the body corporate or the trustees don't ensure that this is in place, it just becomes an absolute disaster. And I have pushed that this has been put into place, and I cannot tell you, it has been absolutely a plus point. We don't have unnecessary accidents anymore. We don't have contractors coming on site with equipment that's not compliant. And yeah, when we talk about contractors, I think that is something we need to look at as well, because there's a lot of fly-by-nights out of there, and COVID is kind of, in my field, I see it, more and more coming on board that aren't compliant in any factor. They just want the job because they need to make an income. I hope that answers your question.
Yeah, very much so. Thank you. That was so useful. And I enjoy this kind of interaction, because that's what we want. We want people to leave with tips on how others are dealing with it. Otherwise, you feel like you're in a vacuum. You know, you feel like only your company does something. But I just wanted to ask one more thing, Marlene. When you say your necessary certificates, what do you mean by certificates? Like certificates that they're qualified plumbers or electricians, or what do you mean by that?
Yes, Marina, that is correct. Every plumber has to do a trade test. There is a specific insurance company at the moment as well. I'm not going to mention names now, but if a plumber comes and does a job for more than 1,500 Rand, he needs to issue a certificate of compliance, and then he needs to be registered by PIRB, the Plumbing Industrial Regulations Board. And yeah, the electricians the same. They need to do a trade test. And they all have these, it looks like a credit card that they carry with them. And if they can't produce that, well, then they're not licensed. And I must say, a lot of our security at the different complexes where this has been implemented causes tremendous anger, because, you know, how dare we ask them for something like that? It also applies to the health and safety. Simple things like safety boots, somebody coming to fit a topping in a kitchen of either granite or Caesar stone or whatever, doesn't have safety shoes on and arrives with a pair of flip-flops, cuts a piece of stone and it falls on his stone. Who's liable? I don't want to go into all the occupational health and safety side of it, but yes, it's a certificate that they all have. Even a stupid thing like replacing a stove plate. He needs an electrical certificate before he can do that, because he could cross a few wires and he could burn down a whole block or a whole unit.
Exactly. Oh, yeah. So Emmanuel says, I like the idea, but the question is, who will undertake the task if trustees are not willing to? Well, isn't that the age-old question of trustees not wanting to get involved? So Danny, Karmel, are you guys going to go on site and do this?
No, unless they would to increase their mandate with us. It doesn't fall within our scope of works. So what I do know that there are certain management companies that do provide a service similar to that. We are branching out into that at the moment currently, where we are basically starting a division with the operations manager, so that he could possibly meet contractors on site and verify qualification, certification, all of that. He's also going to be drawing up a database of verified and certified contractors. So it's obviously an additional service. Let's be honest, it's not like it's going to come for free, because at the end of the day, the trustees are responsible. I mean, that's the whole point behind this. And the managing agent is there as an advisory capacity. We can't make the decisions. We can't do the job for you. We can only advise you how to.
Danny, what's your input on that, rather?
Yeah, I agree. But again, if the process, like Marlene mentioned, if that due diligence process was followed, then there won't be a need for checking up on a contractor, because he's already supplied that information by proving he's compliant to do the work, giving us the proper certification. So it's basically then just making sure that that supplier is competent and can do the work. So there won't be a need for a check on that a service provider at all if the compliance is done in the beginning stages.
Yeah, there seems to me, well, it seems to me that there's an awful amount of work on the shoulders of the managing agent. I mean, there's no doubt about it. At the end of the day, and also my feeling, being in this unique position of working with managing agents, with trustees, with owners in buildings, is that trustees are busy. They're so busy. They're trying to fob things off on you all the time. And it almost seems unfair. I mean, we had a building actually also near the Cape, not in the Cape, but near the Cape, where now solar's the big thing. So now the solar contractors, they've got a contract together worth about 800,000 Rand, huge building, and the contractors had to go on board. So now for the managing agent to take that, it's such a big responsibility to take that on, to vet. Also, the procurement process is about negotiation as well. So if you've got trustees who are fobbing this off on you, then, you've also got that job. Plus you're looking at a real levy collection, plus you've got this, plus you've got that. So in a way, Karmel, I actually quite like your idea of separating a function a little bit, separating that function and having almost another form of, like another income stream in a way. It sounds like a good business approach, but again, that's up to each agency and that would deal with their own business strategy. But maybe we need to start looking at things a little bit differently. We've got just a few minutes left. Does anybody, would anybody like to ask something else? Well, I see Marianne's just asking, does the managing agent trustee check that the service provider has professional insurance? I don't know that you go that far.
Well, Marina, I can say that on our agreement that we send to our contractors that they have to sign, the professional insurance policy number needs to be noted on there as well.
Okay.
So we do, obviously, when we send that out to the contractors who are quoting, they have to fill that in before they can commence with work. So not only is it the workman's compensation FEMA, it's got to be the occupational health and safety rep that's on site. They've got to provide the details of that person. They've got to provide the policy for the indemnity as well, public indemnity. They've got the public liability. They've got to have those in place before we can appoint them.
Thank you, Karmel. Damien, do you have any last words or anything else in your experience that you want to just put?
I think another important point is obviously the payment process, and again, if any work needs, if the contractor has done the work as per the contractual agreement, again, the trustees need to approve that they were happy with the quality and standard of the work, and that the contractor has provided the work as per the agreement and authorize the payment. So again, we are reliant on the trustees to approve any work that has been done at the building.
Thank you very much. Okay, well, I think that's brought us to the end of our webinar. Whenever I finished with a webinar where I'm learning so many things, I always have a renewed respect for trustees and managing agents, particularly portfolio managers. I do, and I commend you for all the hard work that you do. Our aim here at Women in Sectional Title is just to connect us, to inspire us, to make us think differently, maybe think out the box, and just provide the best possible service that we can as well. You can, and us as attorneys, we can as well. So, thanks again to our sponsors. We appreciate you. We look forward to our next few webinars. We've already got them lined up. If any of you have got any other ideas on what you want to hear or what you want to see, please do let us know. Go onto our website, check out all the videos on the videos page, and keep safe and keep warm until we see you next time. Thank you so much.
Thank you.
Thank you.